Mr. Moncla.
Thank you, Chairman Bishop and committee members, for hearing this important severance bill today. Thanks, Representative McFarland, for running this bill for us. House Bill 634 is not a request for a new exemption, and it is not a request to extend or lengthen the exemption. It is merely a bill aimed at clarifying the definition within current law regarding the deep well exemption and when the exemption begins. The premise of this new language came about recently when an operator lost a year of their deep well exemption on the discrepancy of the time frame when the well goes from construction to production. In their conversation with DNR, the regulators recognized that the current language was problematic and urged the operator to seek legislation. So here we are today. Prior to production of oil and gas beginning on a well, it has to be drilled and tested. Then if the test shows hydrocarbons, the operator has to put in a facility to capture the product. The facility can include tank batteries to hold liquids, a pipeline installed to transfer natural gas, a separating system, and other surface equipment. The timing to get a facility up and running varies depending on geographic logistics. If a well is on land and has a gas line nearby, it can take a few weeks or a month or two to begin commercial production. But if a well is in state inland waters, it can take much longer. Pilings have to be driven in order to construct platforms on top of it to support the tank battery and the separator, and a gas pipeline in many cases is further away to try to tie in to a sales line. In the situation of the operator in question, the well was tested, then shut in for construction, and the associated infrastructure and construction of the facility took about a year. The testing was considered active production, which prompted the 24-month exemption period to begin running. But the well didn't begin having commercial production for over a year after the state's term of completion took place. The exemption timeframe should not start until the well starts producing. How can the exemption timeline on a severance tax begin prior to a company beginning to have to pay to sever any products from the earth? The 24-month time period for this exemption should begin at the same time the commercial production begins. And that's all I've got. Thank you for this opportunity to speak to you.
Thank you, sir. Representative Mency with a question. Representative Mency no longer has a question. Representative Boyer.
Well, thank you, Mr. Chairman. Realizing my button's still pushed, I was going to ask Representative McFarland to answer the questions that were just answered. So to kind of give me an example of the reason that this bill is needed. I can see exactly what your point is and can add some confusion. This just brings clarity to existing law, correct?
Correct. Okay. And we do have an operator here. If you need to speak to specifics, they can tell you exactly what.
I think your example speaks pretty clearly to it. And Mr. Chairman, I'll move favorable at the appropriate time.
Not yet. Representative Phelps.
Thank you. That did provide a lot of clarification as well. But just a few more questions for those of us who are really not in this drilling business. You said 24 months. Is that the normal time to start the process?
The 24 months is the exemption they have until they have to start paying severance tax.
Start paying, okay. And not the drilling, because I thought I heard you say something. It should not begin until.
Right. It shouldn't begin until. So after you drill a well, you have to put in a facility, and so basically the rule right now says, or it's unclear. We're trying to clear that up, but the DNR has made this one operator begin their severance exemption right after the well was drilled, but not until before everything was built. So, you know, I spoke to you before, you and Marcus, and I gave you all that example of McDonald's before. If I'm going to use a McDonald's example again.
That was me. I don't remember.
Yeah. But
no,
you know,
I'm not denying it's a good bill. I just want to understand the bill.
But if you're building a McDonald's, you're not going to start paying sales tax on hamburgers until the store is built. So in this situation, the oil well is part of it, but there's also a facility that goes with that oil well, and it's not built yet. So you can't produce oil to sell until that platform and everything is built.
Okay.
So we're trying to just clarify that the exemption will start once the production starts to flow to the sales line.
That makes sense. And the last question was, obviously, this was the time to bring clarification. So when was this adopted before? When this become legislation before? And I'm looking at how long did this take for this clarification?
Years. You know, look,
That
South
sounds-
Louisiana is a deeper area, and it has been very depressed for a 7-year downturn. So there hasn't been that many deep well exemption
Okay.
wells drilled. So, yeah.
That answers that. Makes sense. Thank you.
Okay.
I think currently, right now, there's only one.
Okay, the board is clear in opposition of the bill, not wishing to speak. Caleb Holmes, Sierra Club. Representative Boya has made a motion to report HB 634 as amended. Is there any objection? Seeing no objection, HB 634 is reported as amended.